That's another thing that almost all businesses, if you sell products or services across state lines, you should really look into trademarks. And I've had, clients come up to me and say, man, it blew up on me. I never registered it. And now I'm dealing with somebody who registered it. And even though first in use wins, you now have to go through all the process of trying to deal with this. And now you have brand confusion. You've got, people calling you up saying, hey, I went to your website, but it's not your website, this kind of stuff. So that's kind of the things you got to deal with. And the cool thing about trademarks, patents, you got to do right away, right?
Welcome to Sharpen the Spear podcast, where we help manufacturing executives command the front and win the floor. I'm Richard Walsh, creator of the Sharpened Impact methodology, and I spent decades helping leaders transform frontline teams, unlock hidden profit, and capture capacity they didn't even know they had. If you want to see where your leadership gaps are costing you and how to fix them, head over to grittolead.com and run the free Sharpened Impact Simulator today. Let's sharpen your edge and get started. And we are back on STS Sharpen the Spear podcast with another incredible guest. Austin Bonderer is with us today. And Austin, no one knows Austin better than Austin. So Austin, I need the backstory. Bring us up to speed and we'll get into the conversation.
So basically what it was is that, I basically started my career right after engineering school. I went right to the patent office and I fell in love with intellectual property, went to law school at night, and that's how I became a patent attorney. It's been a pretty interesting ride. Part of my experience is I was a head of U.S. nanotechnology prosecution for a Fortune World 100 company. And now I'm in practice for myself. So now I mainly work with small to medium sized companies and independent inventors to try to help them secure their intellectual property.
That is awesome. And now people are going, what do we got? Why is this guy on? Okay. And there's a lot of reasons. And oftentimes I'm very, what's the word? Self-interested because, I have connections with this kind of stuff too, but I think it's very, very relevant in the realm of business, innovation, all that kind of stuff. It's really, really important that people have a basic understanding of patent law, people who can enforce patent law, right? Because I think it always comes down to, I had a very good friend, one of the top patent guys in the country, right? I mean, this guy closed, holy cow, just a Black & Decker snake light patent case. He closed that. Okay.
Oh, wow. Okay.
Just the money he made on that was unbelievable. Okay.
Right.
It was, he had closed some incredible stuff, and just was fascinating to watch these guys work, but it always also comes down to the power of enforcement, right? That's really what it is. A patent's just a number, a piece of paper, but it's not going to do you any good if someone, he had one, now says a guy had made something for a snowmobile and Polaris took it. So they went to court. It's a great story too. So we'll tell that if we get to it. But then he won that for this guy who built this thing literally in his garage. You talk about.
See, we're two different things because in patents, generally you're on one of either side. Basically, what I tell people, if you see me in a courtroom, bring bail money because I'm screwed. Because I basically write the term paper. I argue before the office and I get people their patent. Much cooler people than me get to go to court and do the whole thing in front of them and the matlocks and all that other stuff. Yeah. I just basically write term papers. So I sit in a dark room and I get that done.
No, I love it. So let's get into that part, okay? Because a lot of people want to do patents, and I have my own family have built things and put things in. It's a very interesting process. So let's kind of give kind of a high level of what that looks like when someone brings you, I'll air quote, an idea, whether that's on a napkin or however they do it. I have no idea. Yeah. But what does that look like?
I've seen it all the way from I've got my prototype, I'm already making this, or here's the back of the napkin type thing. And probably the biggest question I always get from people and stuff is, how do I know if I have a patent or patentable idea? And the first thing I say is, did you solve a problem? And because at the end of the day, patents and inventions are generally solutions to problems. Sometimes they're solutions to problems we didn't even know we had. But at the end of the day, it's trying to make something better. right? Or, improve a process. So, when you get to that point, you need to come to an attorney. And then once they come to me, first thing we generally do is we do a prior art search. Basically, we go out there and we try to do our due diligence to see if it's something patentable. Because believe it or not, I mean, I've had, it seems like a cutting edge idea, and they find a patent from the 1800s saying, hey, this thing was kind of disclosed. I remember working on one case one time, and it was using the thermoacoustic effect, which is basically like instead of using a diaphragm to make sound, it basically superheated material and cooled it down real fast to where it turned the air into the diaphragm. And we're like, whoa, we got the coolest thing going on. And they found something from way back in the day. And obviously, we still got the patent because there were distinguishable differences. But the idea, that basic idea, which hadn't been used before, was actually out there. So, I mean, it hadn't been used commercially in, 100 years or something like that. No one had seen it. So sometimes you do rediscover what has already been seen. And then, once we do our due diligence, we go out and do the prior art search. Hopefully, we don't find anything. Then we prepare the patent application. That takes a couple months. We get the drawings done, we approve it, we work closely with the inventors to make sure, because at the end of the day, the inventor is the one who knows their idea the best, right? I'm just the conduit to try to get it. I'm writing their term paper for them. So they have to approve the term paper. And you really have to impress upon them, like, look, this thing's set in stone. We can't come back later. So tell me what your invention is. The other thing I tell them is, hey, step outside the box. If you were a competitor to you, how would you change it? So we try to include that as well, because once it's disclosed, we can try to claim any part of that invention if it's patentable, but only if it falls within inside the originally disclosed document. So that's kind of how it works.
Wow, yeah, that's I like that though. I like how can it be copied? Right. Like really that's, because my father had built this thing and it was really unique. I mean, it's not a big deal. It's a concrete cart path edger. So you got an
Yep.
edger for doing your lawn, on sidewalk. Well, he's a golf course guy, he's retired now, but 45 years, maintaining golf courses, building it. And out west, they're concrete paths, not asphalt. And that's a long time for guys with a weed whip. Okay, to do those things every week, right? You got 6 miles of cart paths. Okay, and they're doing it by hand. So he created this disc, just a metal disc, like a farming disc, basically, and put it on a sand pro, which you rake the sand traps with, right? It's got the rake in the back, the 3 tires, and you do the whole thing. And put it on there, hydraulics, the thing will drop down the front. It's got the spring, put a blower on the back to blow the grass off as they did the thing. It was awesome. Okay. 6 miles of cart paths in like 3 hours. Okay. And I mean, he developed it, he sold it all over the place, but work on the patents too is like they couldn't really get it. He brought it to Toro and they're looking at it and they want to do this for that. But it was kind of he said he couldn't get one. I don't know any more details than that, but they're still selling the stuff and everything else. But I love the invention aspect, okay, of patents in themselves, right? And then the process. And I think as we talk to you, I think it's this process that the people don't really understand, you know, like
Well, that
quantifying it as a legit patentable item. Okay. There's a lot to that, I think. So when people say months, 2, 3 months, whatever it might be, give us the reasoning for a 3 month thing is, and I know we talked about it a little bit, but like what really is, who's doing all the work here? You, the client, a combination. What's really happening in that discovery process?
Well, okay. So the prior art search, the way it works for me is because, my hourly rate is high. So I
Right.
end up hiring a search firm that I've worked with for a very long time. I trust their work. They go out and search for it. But understand there's always limitations because the way prior art works is anywhere in the world, if something is found, it's prior art. But, we're limited by time scope. So generally, the search firm mainly focuses on US English documents. They're limited by time because we're only going to pay them a certain amount of money. So it's not that they can be 100% sure. We could spend hundreds of thousands of dollars on worldwide searches, right? And when these things do go to trial, and depending on how big the trial is, they will invest that much money in a prior art search and try to find something in Korea or this or that. So basically, with us, when we're doing the prior art search, I tell people it's kind of like insurance. It hedges our risk because we can't afford to spend you know $20,000-$30,000 on a prior art search. We spend the reasonable amount, we do our due diligence. If it's not found, then we feel better about investing in the patent process. So then we go with, I prepare the application, the draftsman prepares the drawings, we go back and forth with the inventor, to make sure that at the end of the day, I'm putting their ideas to paper. And that can be difficult. You give me some drawings and they're like, well, I want you to do a little more of this, which is great because more disclosure, the better. Because once it's filed, it's set in stone. We can't add to it. It's called new matter, and we cannot add new matter to an application. And then once we're done, we file it, and then it typically sits for 2 to 3 years at the patent office, waiting before anyone ever looks at it. So that's when you're at that patent pending process. And and let's get back to kind of what your dad was doing and whatnot. I always tell my clients, like, look, if you have a good idea, once we file for a patent, try and make money. Because at the end of the day, if it's a good idea, it's going to make money, regardless if we get the patent or not. So there are two parallel tracks. Don't worry about the patent. Go out there and make money. If we happen to get the patent and you add more value, especially to your company, especially if you have exit strategies, these kind of things, that increases the value of your product. But if you have a good idea and you're out there making it, I mean, look around your home, your office. There are tons of things that you're buying every day that don't have a patent and people are making money off.
Right. And I think the patent pending, right, is you'll see that on things, right? They'll put a little thing. That's just the scare tactic. I mean,
Right.
let me say this better. That works as that, but really if it's truly registered, it's been submitted, that's the date, right? That's when, so if someone else comes up with this and they file it 8 months after you did, yours is already in. Is that kind of you're first in line kind of thing? Do you have the ultimate right of that?
Right. So you have the right to everything that you filed as of the date that you filed. So in the first to file always wins.
Right.
So we turned into a first to file system. It used to be first to invent. There were too many problems with it. So they're like, let's just not do this anymore. Get to the office, file your paperwork first. First one wins.
Right.
So yes, during that time, if someone comes up behind you, you always have a date that predates them. So you should win if there was ever a conflict between you two. Um, so that's basically how that works. That's why we want to get the application to the office as soon as possible. Now, the United States is pretty interesting in the fact that most countries are, if you publicly disclose or offer for sale before you file for a patent, you've lost your right to a patent. The United States gives you a year from your date of first public disclosure and or offer for sale, whichever happened first, to file your patent application. Now, understand. So you offer a sale, publicly disclose. If someone gets to the office within that year before you do it, and they have patentable subject matter outside of it, of your public disclosure, they will win. So it's still, even though you got that year, don't take advantage of it.
Right.
Plus, if you have an idea that you think is going to be valuable in a second country, understand we have to live by their rules too, which means file the application before you do any public disclosure or offer for sale.
Right. So there's the US patent and there's international patents.
Well, I mean, we would, they're all national. So if you want a patent in Europe, you need to file a patent application in Europe. Now, there's several ways of doing that. One of the things that people get confused with, they call it the international patent application, but it's really not. It's called the Patent Cooperation Treaty. And basically, the way it works is you can file a PCT application, and it literally kind of puts a ghost application in every country.
Gotcha.
But you still have to go back and say, hey, I want to turn this into a real application. So you have to employ local counsel. Like if we were to do the EU, we'd have to get an EU attorney to actually then prosecute that application. even though we had the PCT application filed.
Right.
So that's kind of how that
And
international application works.
so that's like Europe, and then it would be either continents or countries, and wherever you think this thing is going to be used, you'd have to go to those individual countries. Then, not everyone in
Yes.
Europe, but Europe, you got the EU, but yeah, Australia, you have to go to
Right.
Australia, right? And you got to file one there, and New Zealand, and whatever that is. Okay, just wanted to clear. I
Right.
like clarifying that, so it's not just one. It's a lot of work. Okay,
Yeah.
so
And the thing is that you really need to do an ROI on it too. So, I mean, like Australia is a big country, but I think I read somewhere the other day that it's the population of Florida.
right. Well,
So, do you want to
it
invest
was
on
started with prisoners. It was
it?
a penal colony. Okay, so
Sad.
it's probably better. There's not a lot of people. No, I'm just kidding. I don't like that anymore. But, that's awesome. But yeah, it's really and when you talk about the ROI too, because this now we're talking business numbers here. So we always want to look at that too. People like there's, and I'm sure you get the full gamut in this industry. You get people who invent something who just want credit for inventing it. Like, right? There's a lot of inventors. Okay, we can go back to Nikola Tesla, who really created some incredible stuff. Didn't care about pen, didn't care about anything. He just wanted to give everyone wireless. Okay, the dude invented this stuff, right? But then you got Edison, who's more your CEO type, going, I'm going to get everything on this. He's doing patents. He's owning this. That's a whole. If you ever want to have some fun history lessons, go look at that whole interaction. It's pretty amazing. But you do get a lot of people who invent things to invent things. They don't care about selling. I mean, they're innovators. That's all they want to do. They want to give it to someone else and do it, but they will file for a patent to get the credit for what they've invented. What happens to it? It may just sit on the shelf for, get it to the next generation or something like that. But that makes me think. So maybe this is a good segue. What's the time frame on this? I know it probably depends on product. You hear it in the drug industry, pharmaceutical industry. Maybe they have a 5 year or they have a 10 year, or how does that, where are we at on that? You don't have to go crazy, in the weeds with it, but how do different things get different time frames to maintain control of that patent?
No, I mean, the thing is, it's 20 years from the date of filing for all patents,
Okay.
pharmaceutical, everything. My understanding. I don't deal with pharmaceuticals. That's chemistry. I'm like,
Yeah. Yeah.
I could pass that class in college. I was like, I've never seen this again. So skin of my teeth, basically. So chemistry is not my thing. Like, mechanicals and business and stuff like this. But that being said, um, if it sits at the patent office for too long, you get what's called a patent term adjustment. So yes, things will get examined sooner than others, generally based upon the backlog of that area. Because the way it works for patent examiners, and like I said, I used to be one, you become fairly specialized, like very, very specialized. So what I always tell clients is that while there's one U.S. patent office, there's really about 8,500 because that's how
Wow.
many examiners they are, and they're very specialized. And it's not even like, I mean, so much technology. Like I had a group of, like 5 examiners, and we were all in the same very specialized area. And if the claimed invention had one little extra thing, it went to a different group. I mean, this is how specialized they get.
Wow.
So, it's kind of hard to staff for that because technology moves in different directions, right? So the office, back when there were software patents during the internet boom and all stuff, that backlog was probably like 6 years. It was crazy. I don't know how long it was, but it was very long. But say you're in a art that's not very crowded, you might get your patent application examined within a year and a half.
Wow. Yeah. That's really fascinating. Yeah. Like I said, that 8,500 different things it is such a complicated process. And I think just understanding that is good because we all have this kind of thing in our head with patents and our own ideas of how long it should take or would take. But I think the most important, you said going back a little bit, is get out and sell that thing.
Yep.
Just get the thing to market, file your patent, do all that, but get that sucker to market and start making money, you know?
Right. I
It,
mean, there are like 3 things I tell everyone who calls. First one is you don't need a patent to make money. Like we said, look around your office,
Right.
whatever, you'll see a bunch of stuff. You paid good money for it. Someone, put labor in it and they get sold. Two, a patent generally in and of itself will not make you money.
Right.
If you don't have a business plan to monetize this thing, then you might just end up with a very expensive piece of paper.
That's right.
The one misconception a lot of people have is like, hey, I've been this cool new thing. I'm going to approach one of these big dogs on the scene, and they're going to love my idea so much they're going to pay me to see if it works.
Yeah.
I'm like, no, it's not generally how it is. Generally, what happens is you have to make it, you show success with it, you have the patent, then they buy your company.
Right. Yeah,
And
with my
that's kind
dad's
of
edger, I told him when he took it to Toro, okay, they're not a small company. Okay.
no.
And they're complaining about a sticker here and this and this. I go, Dad, just let them rip it off. And then you can sue them in 5 years when they do like $80 million on it. Okay, and we'll just do that. That's
Yeah.
you've already made it works because there's some bad knockoffs of his thing. And after people saw, but they couldn't duplicate what he did. It was pretty cool. But I
Mhm.
was just like, just let him rip it off, and then we'll sue him later. I got a good guy. I got a guy. Okay. But yeah, I really love the aspect of I love the idea of patents. I love the protection of it because we all work really hard. Our intellectual property, as you say, really important. I'm doing a big thing now with the new business that there's a lot of IP and intellectual property, right? I've built all this stuff. I've done it's really unique. And I look at it like, oh my gosh, I spent thousands and thousands of hours building this thing. I'm just going, well, I can use it, but how do I protect it? And now I'm going through all that process, right? Like, how do I do this? And I got it all ready. It's ready, but it's got to be moved, put into more of a proprietary system and everything else, right? It's fascinating because I'm a doer. Okay, Austin. So I'm like, I have an idea, I do it. I don't wait till all my ducks are in a row. I just start fumbling through stuff and I figure it out. Yes, it took me 4,000 plus hours, but it's amazing. Okay. So if I
Right.
would have waited, then you never get anything done. But now I have
You
to
don't.
take it and kind of go, okay, I have this thing, I'm using it, but I got to protect it. Right. So is part of that like what you're doing, intellectual property and things like that? Is that kind of in the scope of what you do as well, or how does that work?
Totally. I mean, so there are a couple things. So, there's many aspects of intellectual property and ways to protect it. We're talking about patents. Generally, when we talk about patents, we're thinking utility patents, but there's also such thing as design patents. And design patents cover exactly the way something looks. So I always, implore people, I'm like, look, we got your utility patent, but if you know exactly what it's going to look like coming off that manufacturing line, we need to get a design patent on it. That way, someone can't make something that looks just like yours. Even if we can't get the utility patent, we can get a design patent. At least you're able to distinguish yourself in the marketplace. Another good thing about design patents is that sometimes you can use it as a hedge against risk, especially say you're building this thing overseas,
Right.
right?
Right. Ooh.
And we always hear that people are using your molds to build their knockoffs. So if you have the design patent, you can probably stop them from using your exact molds. I mean, we've seen this on Amazon. You'll go in and put in car charger, thing.
Right.
20 brands look like the exact same, right?
Yep.
So clearly it's one mold being made to make these things. So if you have a design patent, you can help protect that. Another thing is trademarks. That's another thing that almost all businesses, if you sell products or services across state lines, you should really look into trademarks.
Mhm.
And I've had, clients come up to me and say, man, it blew up on me. I never registered it. And now I'm dealing with somebody who registered it. And even though first in use wins, you now have to go through all the process of trying to deal with this. And now you have brand confusion. You've got, people calling you up saying, hey, I went to your website, but it's not your website, this kind of stuff. So that's kind of the things you got to deal with. And the cool thing about trademarks, patents, you got to do right away, right? Disclosure kills patents. But I had a client that was in business for 65 years and decided he wanted to register his trademark. Did it. Yeah,
His
it was a
last move
great.
before exiting.
Exactly, exactly. Well, I mean, not to get too far into it, but there was some. Like he thought someone might start trying to use and like, well, let's get this registration and then we'll be protected. And that goodwill is very valuable to your company.
Yeah.
You know, there's also copyright, which is more with like books and movies. I don't really deal with that. That's more entertainment law. And then the other one, you know, it typically is, dealing with processes or recipes would be trade secrets.
Uh,
So, I remember there's this one restaurant in LA. I think it's called Crustacean, and it has something to do with the family used to work with the royal family, or was part of the royal family, but they literally have a kitchen inside their kitchen where only a few people are allowed to make the garlic noodles that they're famous for. So when it comes up, they got a little window inside the inside kitchen, so the outside kitchen can actually do whatever they need to do with it because they don't want people knowing their trade secret and probably
Kentucky Fried Chicken, man. It's the seven secret
11
seasoning,
herbs and spices.
whatever it was.
Yeah.
Yeah, whatever that number was, man. The Colonel. The Colonel
We
got
all
that.
the other one's
Yeah.
Coca-Cola,
No,
right?
no, now
That's the
Pepsi owns it. Yeah, I think Pepsi owns it now, right? Yeah,
yeah.
it's kind of funny. So you do trademarking. That's part of your
Yes, both.
business. Yeah, that's
Yes.
awesome. We'll have to talk after the show. Got things. Well, but I really, I think there's, and I like hearing that the difference, between trademarking, patenting, and really usefulness of trademarking, which is a big deal, right? And I've seen
Yeah.
people get kind of stuck, and almost have to abandon a brand because they didn't do the research,
Right.
and then they find out it's already there. We had
Right.
that at a winery down the road from my house, like 2 miles. It was what was it, Dry Creek Estates. So, and they built this amazing winery. Okay, like I'm in Wisconsin. It's like you're in California. Okay, I mean it's
Yeah.
the clay tower. They're just fantastic. Big entryway, with the stone pillars and the steel arch that said, I had in Dry Creek Estates. You see up and like, oh, it's beautiful. There's a creek that runs by and all this stuff. And I don't know. It was 8 months later after they opened. I see it's
Yep.
down. It's off. Now it's DC Estates
Oh,
because
yeah.
because they got a cease and desist on the dry, and they make wine. I mean, it's not just wine, but so that was kind of like, oops, they didn't do their
Yeah.
due diligence. Just like, and I'm just having fun with this. We're on the state line of Illinois and Wisconsin. Okay, literally, you walk across the street, you're in Illinois. So they're on the Illinois side, and they had the property, and they built this whole thing and all this stuff, right? And ask them, now, like, well, what do you think? Well, if I had to do it over again, never do it in Illinois. Because the whole process, liquor license, everything else, like, yeah, we just never again. Okay, but they're there and they're committed and that whole thing. But just fascinating. But that was just one of those. And you know what? I don't blame them. They got a thing. They didn't do the thing, man. They're building a business. They're doing all this kind of stuff. They've got vineyards and all this stuff. But it's just interesting what happens. And it was only till you reach a certain size. Like you might do that in the beginning, then all of a sudden when you're perceived a threat, now it's time. It's worth like squashing you.
Well, it's not even just that. I mean, technically, you have a duty to protect your trademark.
Right.
So as soon as you find out that someone's using it, you have an affirmative duty because then you can lose your trademark.
Mm-hmm.
So, there are actual, like if you have a trademark, there's actual companies out there that you can employ and they hire people in, different countries. And what they do is they scour the internet for your trademark.
Yep. Yep.
Try to find it. They'll send out the, hey, you're violating this trademark, this kind of stuff. So you do have an affirmative duty. One of the cool things that you can do, especially like the winery that you were talking about,
Mm-hmm.
what you can do is, if you're going to try to register a trademark, and you should do this probably 9 months in advance. You can apply for what's called an intent to use trademark registration, which means you're not using it in commerce yet. So you can't technically get a registered trademark, but it's almost like a pre-clearance process. And, I tell my clients, like, look, if time is of the issue, come up with 3. Like, if you're like, we're going to market in like 10 months, and I'm like, well, let's get this process started, but let's have 3 options because hopefully all 3 get through and you can pick your favorite. If they don't, then we have backups. and
Right.
then hopefully it gets through that process, and then you're good to go.
Nice. Nice. Yeah.
But
It's,
it can take up to a year. Like it depends. The offices, they used to be faster in trademark applications, but I think it's 7 months or 8 months before they even look at it now.
wow. Wow. It's crazy. Yeah. It's all that preemptive work, that you need to start doing, and again, as doers and, my thing when people are starting businesses, I call it ignorance on fire, which I have a
Right.
great affinity for. Okay. I like it. Okay. Cause you can go places. Okay. You can get things
Yeah.
done, but you're gonna skip some things. Okay. Knowingly or unknowingly, right? So there's certain things you got to get priorities on, things like brands and things like that. You might want to put that a little higher on the priority list to get that going because that's a big deal.
Right. And that's the thing, I work with startups all the time, and it's, I kind of lawyers can kill your startup faster than anything because, we're like, you got to do all this stuff. And, cash is king. You're trying to build something. And granted, there are things that we truly need to do. And then there are things like maybe we can hold off on because, you know, budgets are not infinite, especially if you're in a startup
Correct.
mentality. You're like, hey, we got to spend a little bit of money on this. We got to spend money on this, and you gotta watch where that inflows and outflows go. But lawyers are very good at saying, hey, we need all this. Pay me
Yep.
all your budget. Now you have no money to start your startup, but you're ready to go, right? I mean, it's
Yeah.
kind of that kind of stuff. So I try to be very careful with clients. Like, this is something I think you should do. Maybe we can hold off on this other thing, but called, what is, I'm sure, people have heard this all the time. My dad always told me there, you need three things: good accountant, good lawyer, and a good doctor, right? You need those guys involved or those people involved in everything you're doing.
Right.
Well, I mean, you don't need a doctor in your business, but you know what I mean. So you should have a relationship with an attorney that at least can point you to something if
Yeah.
they don't know how
Yeah.
to do it.
Yeah. I've shared numerous experiences, legal experiences that have been of benefit. It's easy to say about the bad ones. Okay. But I've had
Right.
some that have saved my bacon more than a couple of times, accounting as well.
Yes.
I learned from an accounting standpoint, I learned to say, no, you're wrong to the IRS. They send me a bill like you owe us. No, I don't. I learned
Yeah.
just that was my new stance. My account told me just say no, no, you don't, and give it back to me. I said no, I don't,
Yeah.
and then guess what? They owe me money.
Right.
Oftentimes it was like no, like why are you an authority? You're a bureaucracy. I should have no trust in that. Okay, I need to
Right.
double check your work. Okay, because you can just send out whatever, and you have fear behind you. They have
Yeah.
that. So that was kind of interesting. And hey, I paid a lot in taxes. Okay, or waited to pay a lot in taxes. So I had all kinds of issues. But I really got to that point where you got to learn how to manage these things. And I think from patents to trademarks, copyrights, intellectual property, like you have to you have to put a priority on it and understand how it affects your business. Okay, I think that's really where it comes to because there's some that are like it'd be cool to have, but doesn't really matter. Okay. I mean, I
Yeah.
write books. I've written books, right? I get copyright on them and all that stuff. That's great. Okay. That's fun. Trademarks, another thing. Right? That's another whole level, right? So what's the purpose of the trademark? Again, in my own business, how does this affect future business? From copying to assimilating or whatever that might be. I think it's really important that people understand the level of protection that it is. It's risk transfer, right? A trademark's risk transfer. I'm transferring the risk of someone copying this to the trademark, right? To the legal aspect of having a trademark on
Right. So here's a little misconception so if you enter business like the estates people,
it. Mm-hmm.
they had a trademark. What I do is I help people get a federally registered trademark, which offers a lot more protection. It basically gives you nationwide protection, and that's kind of what it's really beneficial for. Because now you have an official document. You can go to Amazon, here you go. That's trademark infringement. You go to Alibaba, here's registered trademark. Those are the things that help. Two, if you have a federally registered trademark, it's I mean, registrations can get canceled because, someone shows up and like, I've been using this for years, but it makes it a lot harder. And you have a lot, all this is hedging risk. This is basically what it is. You can get issued a patent that is invalidated later. But at the end of the day, it's hedging risk. We're getting these certificates, we're getting these government documents, we're getting these government protections, and that it gives you the at least a comfort level of investing in your goodwill, in your advertisement, in you're putting your product placement because, you know, God forbid you spend 20, 30,000 on a startup budget trying to get your name out there, and then all of a sudden you got to change your name, my kingdom for a horse type
That,
stuff.
that can be a business ender.
Yep.
That can take you down. It really can. So let me understand. So I think I missed something. You have a federal registration for a trademark. What's the other option?
Well, you've probably seen it before, TM.
Right.
That's common law trademark. So understand the purpose of a trademark. It's not, I mean, it does benefit the business owner trademark. There's value in it and all this kind of stuff. But at the end of the day, a trademark's really for the protection of the public, right? It is there so people can make snap, informed decisions on what they're buying,
Mm,
right? So it has to be a product or service that you're in commerce. That's, in order to have a trademark. So I don't know if you remember. I mean, I'm probably too old. Probably should stop using this But do you remember Coming to America and McDowell's?
yeah. Yeah.
Like the old
Yeah.
guy had a
Yeah.
he had a restaurant that looked
Yeah.
just like McDonald's,
A
right?
great
But the
movie.
problem is, use that as an example. Looks like McDonald's. You go in there, say the hamburger was not as good or not what you're expecting. Guess what? You hate McDonald's now.
Right.
And that's not fair. So
Yep.
the whole point of trademarks is to protect the customer there. So when they go into something that looks like McDonald's, they know it's McDonald's. You cannot have, I mean, the biggest, you know, thing for trademark law is likelihood of confusion. Are you likely to confuse a consumer of these products? And that's what will prevent you from getting registration or when you get sued of, hey, you can't, it doesn't even have to be the exact same name. Say the Dry Creek Estates, let's just go with that one. Say it was Dryer Creek or Drier Riverbed or something like this, or Dry Riverbed. You know, there's a possibility when people are making snap decisions, oh, okay, I just picked up that one. It was the wrong bottle because I was confused because I knew one trademark and I confused it with another.
Right. Yeah. We have another, you're probably familiar with Quick Trip. You got
Hmm.
your QT down south. You
Okay.
got your KT up here, Quick Trip.
Okay.
Okay. Now, so again, I'm the Wisconsin Illinois border. They open one right across against Highway 90, right? They named it Quick Star. It's still Quick Trip with a
Right.
KT, but they didn't want to go through the hassle in Illinois because there already was a Quick Trip,
Okay.
right? Like of a different ownership, everything else, it wasn't there. And they're a brilliant model. Love it. I mean, it's like one of the coolest business models ever. So they just called it Quick Star. Everything's branded the same. It's just
Um,
the name Quick Star, but you go and it's exactly the same place. But it was going to be such a hassle to battle all that out. They just, boom, we just Quick Star, because it's right there. It's literally, it's at the state line. So it doesn't matter. They're just on that side. So they use that to just we'll work on that. And you know what? It's a little bit different on the printing. It says Quick Star, but it's all the same color, everything
right.
else. So
And then you get in your hassle of something like that, like quick for a convenience store. It's
right,
such a adjective that's so synonymous with that likelihood you don't have great protections
right,
in the term quick or the way you spell it. That's probably why you have so many variations of it,
yep,
but you wouldn't be able to do the exact same spelling. There has to be
right,
some
yep,
distinguishing. But we go back to the one I always use is American Airlines. If you look, they always use a TM because
right,
they could never stop Delta from saying we are an American airline,
right,
right? It's because it's descriptive of exactly what it is, right? And they cannot prevent any other American airline from saying, hey, we are an American airline.
right. But you know what's interesting about that is this is kind of a testament to the power of brand. Why would you? Because you're actually promoting American Airlines. right?
Mhm.
So their brand is American Airlines is American Airlines as a brand. Okay.
Right.
But if you were to be Delta and be saying we're an American airline, you're actually that's kind of self-destructive.
Could be. I
You
mean,
know what
but
I
you
mean?
could
I'm
yeah.
just taking the kind of the business point of view. Like I would do everything never to say that. Trademark or not. Okay.
Right.
I don't
Exactly.
want to give them any, I don't want to give them any, misdials. Okay. So
Right. I mean, what was it during the cola wars and stuff? Like,
right,
Pepsi, they were like, "Don't say the C word," like
right,
you can't
right.
even mention it. Yeah, yeah.
Yeah. Yeah, it's really, really fascinating, but I just but most people, I think, Austin, when you're talking about getting trademarks on their things, I mean, there's tens of thousands of small businesses, okay, that still regardless should have this protection, okay, because you never know where your business is going to go, but it also even regionally, okay, maybe you're in a 50 square mile region, okay, maybe you got a couple of businesses there. Well, that's a thing. Okay. And you say, I'm never going to do more than five and I'm not going to worry about it, on this. But then all of a sudden you're 65 and you give it to your kids got a lot of energy and they decide
Mhm.
they want to be in 9 states. Like now it's an issue, right? Now that kind of stuff, So you got to be a little forward thinking on this stuff. And protection is protection. Put it on, be done. Let it be there, and that's all good. And then, like you said, that TM is it's a stopper, just like the little C in the circle. Okay, it's a
Uh,
copyright. Now, some people put it on there regardless if they have it or not, but someone still has to go through the legwork to
Well, no, actually, with the TM, you literally just put it on
yes.
there. Anybody can do it. So the first thing anybody calls me, like, "Hey, I'm doing this thing," I'm like, "Put a TM on the back of it," because that literally indicates to everyone you're claiming it as a trademark.
Well, good. I've done the right
So
thing in the beginning. Thank you. I feel
yes,
better now.
right. But of course, if you have any interstate sales, you want to start looking at federally registering because you don't want to like look. What if you can't get a federal registration? What if there's some reason they don't like it and this kind of stuff? When it's easier to change a brand name when you're young than it is when
Yep.
you are,
Yep. Oh, you're kidding. That's one of my failure stories. Changing a 20-year-old name company because you think it sounds cooler. Yeah, don't do that.
no, don't
I
fix
like
it if it ain't broken.
I refer to it as the final nail in the coffin. That's what I refer
Right.
to back in the day. But yeah, there's a lot of little dumb things, that you need wise counsel around you, And to that point, I'm telling you, like if you have a question, you got to reach out to someone like Austin, on this kind of stuff. If you're even like, do I or don't I, make a phone call, send an email, I don't know, get out there and find out like what are my options here? What am I doing? What are the repercussions if I don't do this now? Right? Stuff like that. I mean, I think that's important. Um, a lot of people just run and gun. I used to do that when I was young. I was
Yep.
young, run and gun. It was just what I did. So you weren't really thinking about those kind of repercussions now because you're too busy building. You're so busy going forward and building a business that makes it super difficult to really let's think about if I should have a trademark. You know, it's just one of those things that are difficult to put into perspective.
Yeah. I mean, what is it? You, I also say that, lawyers ruin everything. We're like, slow down, don't do this, but you need to move the speed of business. It's like you said, it's run and gun, it's go. And then, when you're young, I always said you learned a lesson, right? The more expensive the lesson, the better it was, right? I mean, that's
That's
kind of,
right. Education
and
is expensive. Yes.
education is very expensive, no matter which way you do it, right?
That's right.
So, and you hope you have just call, and that's the other part. Like, look, if you're doing this and you don't know, call an attorney, call three.
Right.
Most of the time, they'll sit on the phone with you for 30, 40 minutes, just shooting, giving you kind of free tidbits of advice. And then, make sure you like the person that you go with, because at the end of the day, the more invested they are in you, the more they're going to know the little bits of your business, this kind of stuff. So they'll be able to see the landmines. Um, and that's the other thing. Like, I mean, you really should keep your attorney abreast of what you're doing because,
Right.
I've seen this in the trademark area that I've had clients where their old trademark attorney didn't, they just said, give me what you got and I'll do it. As opposed to actually learning what they were doing and seeing where they were branching into and saying, hey, we need protection in different areas of trademark law, because the way registration works and trademark works is it's all about area of goods and services. So you can't, you might have protection for Acme Cosmetics, but that wouldn't extend to Acme Oil Company. So you might be a cosmetics company, and then all of a sudden, like, that you might move into hair products, which might be a different class. So you need to register in that class too before someone else gets in there as well. Or you just, your product line just varies. Like you might have an offshoot that, but if your attorney doesn't know, they're not going to file in that class, and then you've lost protection in that class.
Right, right. That's important. I think that's a really good, a good recommendation there for sure. I think often, I'm going to pull AI into this for a moment. Okay, because don't we all love AI? Okay, well, I do a lot in it,
Yeah,
but you can get that, and it'll do things too. It'll automatically put, like when I'm doing stuff, and it'll automatically put a TM on stuff that I
yep,
create. Which is good because I have no way to do that in the typing. I
right.
have no way to make a little TM. Okay, so I need to put that as a key on the keyboard so I can just do it on everything I want. Whatever I say, I need to put a TM on it. But you look at it, it's like, okay, well, that's kind of cool. And then it knows, okay. And I don't recommend people go to chat for their legal advice. Okay. Because I have a saying I've shows all the time, but chat is built by humans, so it's guaranteed to do two things. It lies and it's lazy. Okay.
Very.
So it's always gonna lie. Not always, but you know what I mean? You can fact check it without a lot of effort. Okay. And it's giving you the easy answer. It's giving you the easiest answer. Okay. Doesn't mean it's right or wrong. Just means it's the easiest. Okay. And it wants to make you feel good. That's its other job, is to make you feel you're amazing. Okay. Because you're its customer. Okay. And if we don't treat our customers nice, we lose customers. Right. So people need to understand these
Yeah.
basic things, like it's a tool. Okay.
Right.
But don't build your life on it.
Right. No, I've seen too much with it. I've seen it wrong too many times in my area. And then I'll ask it, like, are you sure you're correct? You're absolutely right. I'm wrong. Like, I mean,
Oh,
and it always tells you what a
brother,
wonderful question this
I
was
could
and what
spend
a great
hours.
idea.
Yeah.
Yes.
It'll say that's on me when I call it out. I'll
Yeah.
call it out. You can't do this. Oh yeah, that's on me. I'm like,
Yeah.
darn right it is. If you're a human, you'd be getting choked out. Okay.
Go to jail right now.
That's right.
Exactly.
I'd be in
Yeah.
prison because I killed you.
Uh,
Okay. But yeah, it's no, but yeah. So that's just one of those cautionary tales. Be
yeah.
really
And
careful.
and really check the sources too, because you know a lot of AI, when I've asked it questions and played around with it, what you can tell is it's just doing a Google search, or I mean, an internet search. It finds some source and just paraphrases it for you. And you're kind of looking at it like, that's a Reddit article. That's literally some
It's
guy's
it's
opinion
it literally
on
is
the
the
internet
greatest.
about something.
It is the greatest plagiarizer in the world,
Oh, yeah.
and it gets to do it all legally.
Yeah.
Okay, you think about it. I have a client, and she got a lawsuit. She used a picture that had no copyright, no watermarks, no anything on it, off the internet on her website. She gets contacted, whatever it was, 2 months, 3 months later, like kind of a cease and desist, and she did. Forget it. They $120,000 they're suing her for 120,000. And I'm like, okay, this is an AI tool that some attorneys figured out to go scrape all the stuff like you were talking about
Yep.
earlier, find all these violations, and see who's going to roll over for it.
Oh, yeah.
It's just like, who's going to pay? We're going to
Yep.
go through all this stuff. It's like, I mean, when she told me that, and legit, and she'd never, it was her intention was never, was never, to rip anything off. It was really, it's just a picture. There's no copyright. I don't know anything. So I mean, usually they get a watermark, they get a copyright or
But the
something.
thing is that technically you have a copyright on anything you produce.
Right.
Right. It doesn't have to say copyright. So, and typically, in order to sue, my understanding, I don't deal with copyrights, but
Right.
take it for what it's worth. My understanding is like you get a copyright on anything you produce: music, art, this, pictures, photography, all that stuff. But in order to sue, then you have to register it with the Library of Congress, which takes 10 minutes. or something, anybody can do it. And then you're able to like sue. But you can tell people, hey, that's my picture, take it down. Now, going after someone after they took it down voluntarily, not knowing, like
Right.
that's just
But here's the thing: it still
that's
costs her an attorney fee
of
because
course.
someone has
Well,
to
I mean,
fight it. I know I'm with you, but I'm just saying like that. That's the injustice part.
well,
Like
that's the reason why I tell people I'm
scrapers,
not a real attorney. I'm just an engineer with
yeah,
a law degree. But
yeah,
I mean, I am, but you see what I'm saying, right? Because,
right.
I don't like a lot of what attorneys do. And, there's so many. And of course, it spans. There are a lot of good attorneys. And then there are people that I'm like, man, you're really giving us a bad name.
Well, it's I think Shakespeare said it best. First thing, kill all the lawyers. Okay. He was eloquent that way. Okay.
Yeah, very
And then
eloquent.
I
Yeah.
had a very good friend, very high end attorney, retired, everything else. And I'll just share that. I'm going to share some humor. Okay.
Okay.
So here we are. So he said there's two lions in ancient Rome walking down the street, and they come on a pile of dog excrement, and one lion eats it, spits it out. They keep walking. The other lion's looking at him. And they go to the next, finds another pile, and he eats that. And he spits it out. And the third time this lion does it, his buddy, so go, what are you doing? He goes, oh, I just ate an attorney and I can't get the taste out of my mouth. Oh, yes, he told me that. My friend told me that.
Yeah,
Lawyers have great lawyer jokes. They're funny.
of course.
But that's enough of that. So yeah, just there's legal implications. There's risk transfer. There's just brand protection. Okay, a lot of little things we can stack up on this, and I just want to kind of drive home the importance of this stuff. As we're kind of wrapping this up here. Just so let's give us kind of that some final thoughts on trademarks and your patents and these kind of things. Like we've done a great job so far putting all this together. Kind of put a bow on it for us, Austin. So people have the final understanding of what all this is.
Okay. So, I mean, there's a bunch of subjects there because patents are different than trademarks. But
Right.
first thing to understand, keep in your head, disclosure kills patents. Shut up. Like, don't tell people. And it's a weird thing because when you invent something, you are generally pretty proud about it. You're like, look how clever I was. I solved this problem. I've been working on it for a while. There's a sense of accomplishment there. I tell people it's kind of like putting your baby on Facebook, but here, don't. And if you really feel that strong that you need to talk to somebody about it, just call an attorney, talk his ear off. You'll feel a lot better and then decide if you want to move forward with the patent or not. With trademarks, so keep in mind, disclosure kills patents. And, when it comes to trademarks, just do simple searches. Use the trademark search tool and put in the name, and you'll find something generally, but make sure it's in the classes that you're working in. Now that might be difficult and you might not get a hold of it, but the trademark office has a lot of good videos explaining in layman terms what to do, how to search, and what you're doing. They may even have a help desk that would help you determine which class your products are in so that you could do proper searching. um, and with trade secrets, it's generally you need to talk to an attorney. Trade secret has to be secret. Like in generally and for real, you need to talk to an attorney because you need to have SOPs in place that clearly make it clear that this is a trade secret. Your employment contracts need to be totally clear. You need to limit the amount of people who actually know this secret. Those kind of things, and only certain things can be trade secret. But talk to an attorney. I mean, most of the time they'll talk to you for 45 minutes for free. Call 4 or 5 of them. You'll probably get everything you need to know.
Right. Yeah, that's great. That's awesome. So I'll share my final little story about patent infringement. So my buddy, he was a huge patent attorney, enforcer, and he had a guy who created this thing for snowmobiles, right? Literally in his garage, really like his whatever it was. Well, Polaris ended up having that thing. They stole it. Okay. So talk about not keeping your mouth shut or whatever. So now they're in court. So years have gone by. They're in court. There's TV screens, all this kind of stuff up. Every engineer from Polaris is there and all this stuff. And here's this dude with like the baseball cap who made this thing in his garage. And he's just sitting there. And he's telling us the story one day, and he's like, so they're trying to get the TV thing to turn on, and they got all these engineers and no one can figure it out. They got all these buttons and none of these engineers can figure it out. So the judge goes, well, you're an inventor. How would you turn on the TV? To the guy in the basement? He goes, well, push that button over there and then push that button. And boop, 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 everything came on. Court over, court adjourned. They won the court. He goes, there's nothing I could have said better than that. He goes, we
Right.
closed that, and he made some huge money on that one, right? But like that was it's just those are those cool things, right? Like you actually invented this thing and everything else, and someone gets it. So like I said, one of the greatest stories ever. Just awesome. So that kind of stuff's cool, but don't rely on that. Okay. Like
you don't want to get to court. The whole point is not to go to court. Court
exactly.
Sucks. Don't do it. I mean, lawyers who go to court love it because they make a lot of money.
Win.
And make a ton of money. Even if they lose, they make a lot of money.
Yeah, that's what divorce attorneys are. No one loses except the couple.
Well, yeah, there's an old joke. Why are divorces so expensive? Because they're worth it.
Right. Yeah, I've had all the experience with that stuff. So not divorce, but
with attorneys taking your money.
Attorneys, legal stuff and business. You both sides of the fence. I've been deemed an expert by a judge. I've gone in and won cases for my clients who have against other people who did what I did. So that was really cool. So you get that, and they, and then there's times you lose. Okay, so it's just welcome to life. That's how it is.
Right. And the weird thing is like that's the problem in court. You can literally be 100% right, especially in patent cases, because the big problem is a lot of these judges never went to engineering school. Almost all of them. I mean, I would say very, very, very few. And you're talking about very technical things. Two, if you're arguing in front of a jury, most of them never went to engineering school. In fact, the other side will probably try to get those people kicked off. Then with the less educated STEM people on there off. So now you're dealing with it really does fall down to how good your attorney is sometimes. Even though you have all the facts on your side, it's a gambit. It's a gamble, and I try to keep people out of it.
Yeah, there's a brilliance and a downside to everything. Our court system is that. There's nothing better in the world. Yet there's, it's like anything. People learn how to game it, how to play it, how to do it. Yeah, it comes down to personality. It's all kinds of wild stuff, but it's just not the facts. It's just not.
It's not a perfect world,
and you think it would. And if you're an engineer, you'd probably go crazy because it's not right. Because that's what you deal in. I deal in data. I deal in facts. I deal. So
well, that's kind of the issue with patents is because at the end of the day, you're using words to define items. And when you use the term fastener, that can mean, like, what does that mean? So in reality, when you have a full patent infringement lawsuit, you really kind of have two trials first. You have a trial to actually determine what all the words in the claim mean.
Definitions.
And then you have a trial to determine if you're actually infringing what the first trial said the claim meant.
Yeah, that totally makes sense. Because words have meaning.
Right.
Call me Captain Obvious, but people don't realize that sometimes in the things they say. Okay, they actually have meaning, so it matters. So, Austin, this has been awesome. This has been absolutely great. Who else, except guys like you and I, could talk about trademarks and patents for an hour like it was 5 minutes? You see?
I don't know. I'm sure we put a bunch of people to sleep, but
then they needed a nap. The only reason it was because they needed a nap, and they can thank us later for that.
Exactly.
When they listen to the recording or whatever.
Right.
Okay. But so how do people get in touch with you? How do they follow you? You know the drill. They want your services.
It's actually kind of cool that my last name is Bonderer, Bonderer. And you just put in bondererpatents.com is my website. But if you just put in Bonderer and patent, I should pop up probably one of the top, I assume the top, unless someone else came along and started.
Just put a TM by your Bonderer. Just put a TM. And you'll have it. Oh, that's awesome. That is awesome. So I definitely, if you guys are questioning your, do I need a trademark? Do I need a patent on something I'm doing? Whatever, reach out to Austin here. get some insight, and if you need to get it done, have them get it done. Why waste
Yeah.
any time? Just go to Austin, he'll bang it out for you and get it done. I know it's not an overnight thing, but still, get the process rolling sooner than later. Protect your intellectual property, protect your inventions. It's your business, it's your brand, it's everything else. All this stuff matters very much to your business, and we're just bringing it to your attention here
Yes.
today. So, Austin, thank you so much for the time today. It's been just fantastic. Glad we were able to finally get it done. I know we struggled getting together, but here we are. It's been amazing. And for everybody else, I'll see you on the next STS podcast. Thanks for joining me on the Sharpen the Spear podcast. If you're a manufacturing executive and you're serious about unlocking hidden profit, improving frontline leadership, and taking control of your floor, go to grit2lead.com right now. Run the free Sharpened Impact Simulator and discover your biggest opportunities are hiding. Don't leave millions on the table. Sharpen your spear, lead from the front, and win the floor. Until next time, stay sharp.